Um, Let me thank the American Constitution Society for putting together this very timely conversation and discussion on the constitutional powers of the presidency and shattered norms. And so we have a very distinguished panel here, and I think that many of our students know at least two of the panelists, and probably have seen the third one many times on CNN. But let me start out with Carlos Gonzalez. He's the professor of law and Herbert Honig Scholar here at Rutgers Law School on the Newark campus. He, of course, is an expert in constitutional law and has taught many generations of students con law over the years. We also have Stacy Hawkins. Stacy Hawkins is a con law professor on our Camden campus. She's also an expert in employment law and the creator of the seminar, Diversity and the Law. She's written most recently on judicial appointments, something that we're going to discuss today. And then we have Ellie Honig, who is a visiting scholar at Rutgers University. He wears many hats, so I know I'm going to miss many of them. He's the executive director of the Rutgers Institute for Secure Communities. I think most of you know him as a CNN legal contributor who frequently talks about shattered norms. And he's formerly with the U.S. Attorney's Office for the Southern District of New York, where he tried cases involving organized crime, human trafficking, and he's also formerly with the law firm, with Lowenstein.
Unless they just fire me in the last few minutes, it's still happening.
Okay, that's good. You wear way too many hats, so it's just hard to go
Tell me about it.
So I want to jump into the conversation, but I want to really start out first with reflections on Justice Ginsburg. I know that we're going to talk about the nomination process today, but if you all would just say, if you spend a couple minutes talking about Justice Ginsburg and her contributions to this country. We'll start with Professor Gonzalez, who's on mute.
He's muted.
Okay, I've just come off mute. I had on. Always try to prevent the crosstalk. I can't even begin to do justice to Justice Ginsburg's legacy and impact on federal law and on the Constitution. I'm not even going to try, but I'll just sort of use it as an opportunity to open maybe one of the issues that will come into the discussion today about the nature of the court, how justices are selected, and questions about whether the court really is a neutral arbiter of federal law and constitutional meaning, or is really now becoming, or really has long been, but now increasingly perceived by the public to be just legislators in robes. And I think the aftermath of Justice Ginsburg's surprising and untimely passing, immediately we see the political aspect of the court come to the fore just within an hour of the news coming out. And no one knows how it's going to impact the election. There's a lot of speculation about that, but just the way that it's being discussed, any sort of facade that there's going to be an attempt to pick someone for any other reason than the substantive outcomes that will be expected, the way they'll vote when on the court. That is, if that existed, it's clearly gone at this point.
Professor Hawkins?
Yes, I agree with Professor Gonzalez that it's certainly impossible to fairly capture, quantify, or even at this point predict the full impact of Justice Ginsburg's legacy on the court, and how awesomely her loss will be felt on the court. But one thing we know for sure is that this has even further politicized the court, right? The fight over her replacement. And part of what is at stake, notwithstanding the fact that Justice Ginsburg herself, famous for dissenting, was part of a liberal minority wing of the court, was at least part of a very delicate balance on the court that has existed for the last 30 some odd years, where while the court tilts slightly conservative with a 5-person conservative majority, there were 4 liberal justices on the court, and often they were capable of convincing one of the conservative justices, usually considered the moderate, to swing to the left and join them in important decisions. And that possibility has become even more remote if Justice Ginsburg is replaced by a conservative. And so it really is critically important how, her loss and her likely replacement by not just a conservative, but someone who's likely to be far right and not even close to a moderate justice will impact the delicate balance that has existed on the court for more than 3 decades.
Professor Honig?
Yeah, so 3 things, and I agree with much of what both Professor Gonzalez and Hawkins said. First of all, let's just start with the raw numbers here. What was 5-4 conservative edge now becomes 6-3. And Chief Justice Roberts was a key swing vote, especially in the last term. He came over and joined the liberal side on the DACA decision, on the LGBTQ equal rights decision, on the Trump tax returns decision, on the census citizenship question decision. All of those he swung. A couple of them he was joined by 1 or 2 others. Now, even if John Roberts swings over and joins the liberals, not enough. As Professor Hawkins said, you're going to need 1 more. The other number I want you to think about here is 48. 48 is the age of Amy Coney Barrett, who seems to be the leading contender for this seat. Judge Barbara Lagoa from Florida is, I think, 52. But here's a little fact for you. The oldest justice on the court right now is Stephen Breyer. He's 82 years old. He's one of the 3 liberals. And the 3 youngest, once we get this nominee in, will be all from the conservative side, Kavanaugh, Gorsuch, and either of those 2 women. So that's the long-term outlook here. With respect to whether judges are neutral arbiters or political actors, we'll talk about that a lot. In our ideal, they should be neutral actors, but I think there's just no way around the fact that largely what they do is political. And I will say the liberal wing has been more reliably liberal than the conservative wing has been more reliably conservative. I mean, I just ticked off 4 or 5 of the biggest cases from the last term where Chief Justice Roberts went over and joined the liberals. You can't point me to a major case last term where any liberal went over and joined the conservatives. That's not to say outcomes always have to be 50-50. Sometimes one side is right more than the other. Justice Ginsburg, let's be clear, was very, very reliable in where she would come out ideologically. And I think nobody who was on the court in 2000 for that 5-4 Bush-Gore vote will ever, either side, be able to explain their vote away as anything other than a pure exercise in political power. You cannot tell me if the vote was Gore up 500 votes instead of down 500 votes, every one of those 9 would have come out opposite. The last thing I want to say about Justice Ginsburg, I can't, like the other professors, I can't even begin to discuss her legacy. She's known for her powerful dissents, for her eye towards the real life applications of her decisions, the fact that these would impact real people. One thing I was struck by was her sense of humility. And I came across this quote from her, which really, I really appreciated. She was asked about what it means to be a Supreme Court justice. And she said this: "One could become arrogant or imperial." And we'll talk about several actors in our government now who have done both of those things, including the president and attorney general. "One could become arrogant or imperial, but Supreme Court justices know that the Constitution places great trust in the court's hands, and fidelity to that trust makes us approach our work with due humility." That word humility is something that is really missing, I think, from our public discourse and debate right now, and one of the many things I hope we remember her for.
And of course, go ahead.
Yeah, I just wanted to respond to one of the things that Professor Honig said. I think it's a little complex. In my view, it's a little complex to sort of parse out this issue of who's the more reliable vote, or the conservative justices, or I'll call the Republican appointee justices versus the Democratic president appointee justices. And what I see is that, yes, it's true that from time to time, the Republican appointees, most notably in this term, Justice Roberts, there was also a one case where Gorsuch did this, one prominent case.
Yep.
Before he left the court, Justice Kennedy did this in the Obergefell case, other notable cases. It's absolutely true that there are times when some of the Republican appointed justices, or at least one of them, has come over and joined the liberal wing of the court to form a 5 or sometimes 6 justice majority, and that the Democratic appointee justices have been less likely to do that. Although that also has happened from time to time. I think it's true that it's less likely, but why is it less likely? And when you get that 5-4 majority of really all of them, especially after Kennedy left, but even when Kennedy was on the court, Federalist Society vetted and approved Supreme Court justices, that changes the dynamic of the cases that are brought and the way that they're litigated. So conservative litigation outfits are much more aggressive in the types of constitutional law and federal statutory theories that they're willing to bring into the federal courts and ultimately to the Supreme Court, because they think they may have the votes. And sometimes they push the envelope and it turns out they fall a vote short. So when I look at the court, when I look at the Democratic appointees, they're not that liberal. Breyer is very centrist. Kagan's very centrist. You could say Ginsburg was the most liberal, but she's not particularly liberal if you compare her to Justice Brennan or Justice Douglas from times gone past. And really the dynamic of from time to time, the Roberts or the Kennedy joining the Democratic appointee, joining the liberal wing, is more because conservative litigation outfits are bringing some very outlandish and aggressive reach legal theory arguments to the court, thinking that they have, hey, we've got a chance. We might get the 5 votes. But when they're that aggressive, it does from time to time cause maybe a Roberts or a Kennedy or maybe a Justice Gorsuch to peel off and join the liberals. So it's kind of hard to parse who's, why are they more willing to switch sides or vote with the other wing of the court? Is it because they really are following the law more, or is it because of the more aggressive litigation strategies of conservative public interest litigation groups? And so that's sort of maybe a sidetrack, but
great point and well put. And I would add, it's not merely these conservative litigation outlets that you referenced. Administration. I mean, the Justice Department and the White House are taking quite extreme positions. So I agree with that. But you take pride, being a Jersey resident, as I think most of us are, that one of the only decisions in this past term that united everybody 9-0 was throwing out the bridge gate. Now, for different reasons, but that was a 9-0. Well, I don't know what other state could unite Ruth Bader Ginsburg with Clarence Thomas and Brett Kavanaugh, but they all agreed on that.
Okay.
So let's talk about norms. I know that Professors Hawkins and Gonzalez teach constitutional law. They teach constitutional doctrine, and I'm sure they teach it as a very complex and open-ended subject. But norms, what are norms, and why are they almost as important as the doctrine right now? And how do they relate to the upcoming Supreme Court justice nomination and confirmation process? Who wants to go first? Jump in.
Well, I guess I'll jump in. And boy, where to begin on this? I mean, this as we were saying before the event went public, or for the whole group, you could go on all weekend about this. So I'll try to limit me, and Dean Lopez, I'll ask you to cut me off because I tend to go on too long. But so I'll kind of give you my general take, and maybe that'll stimulate some of the conversation. I think students who've had me in constitutional law, some of them will say, boy, professor, you seem to be kind of down on our Constitution. You don't seem to be a big fan of it. And I have to say, maybe I'll say guilty as charged on that. My general view is that we have a brief Constitution. It was drafted a long time ago, 240 years ago more. And even if you look at the drafting convention in Philadelphia in 1787, they kind of, the work dragged on through the summer. As they got into late summer into September, they kind of rushed through a bunch of issues and let committees draft up language where they couldn't agree. And so we have a constitution that in very important areas lacks detail and specificity. It's about 4,500 words. I like to tell students it's about the length of a sophomore in high school's term paper. And here we are all these years and centuries later trying to figure out what can the president do? What is the president not allowed to do? And I don't think this is not how you'd run the show if you could structure it optimally. But yet we've kind of like muddled along decade after decade, and in some ways very impressively, because we've had these peaceful transitions of power, and outside of the Civil War, in the 1860s, we've been able to use this highly imperfect document in a more or less functional way. But that's only because it is embedded and fortified with a series of informal norms, as opposed to the formal legal norms of the Constitution and the Supreme Court decisions that kind of fill in a lot of the details. Without those formal norms, and if every player in the system ignores and throws those norms in the trash and plays constitutional hardball, then the real flaws and ambiguities and lack of providing clear answers to foundational constitutional law questions like, hey, is the president allowed to do this? Yes or no? Can states do this? Yes or no? Things like that. Without these norms, without people being constrained, without government actors and the president being constrained by these norms, then the flaws in the Constitution become ever more manifest, right? And so we have a president who is not of government. He never held elective office before, so he doesn't know the norms. He has a psychiatric profile that even if he knew them, he wouldn't care what they are. And so he just never follows the norm. He does what he wants to do in his interest without regard to these norms. And his party is not operating as a check on him in a meaningful way. And so it is exposing the flaws in our Constitution that have been there all along, but have to some extent or a greater extent been really kind of papered over and smoothed over by the fact that not just presidents, but also Supreme Court and Congress, they have adhered to this unwritten set of rules to constrain their behavior. Now that we have a president that is not constrained, we've gone through this dozens of times. He can't do that, can he? Oh, he's doing it. Who's going to stop him? It turns out no one. Or maybe that's a little bit of an exaggeration. Sometimes federal court litigation is a break, but it's 3 years later. It's taken too long. Just one example of that is Congress's attempt to use its subpoena power to conduct oversight over various, the president himself and or executive branch agencies. The Trump administration says we have absolute immunity against appearing before congressional oversight hearings. And even beyond that, very expansive notions of executive privileges. And the truth is, we don't have case law that provides clarity on this. And so here we are, and month after month this has gone on, and Congress cannot perform a check function on the executive branch. And the federal courts have been slow and, in my view, overly reluctant to step into the breach and clarify the scope of Congress's power so that it could perform a check on the president. So without any norm following, we're kind of exposing the pre-existing gaps and flaws in our Constitution. And we have a president who really doesn't, he doesn't care. He's not going to follow the norms. No one's been able to convince him to do that. And so we need to rethink basic constitutional concepts, and going forward, piecemeal reform is not going to be enough. And I think I better stop, otherwise Dean Lopez is going to stop me. So.
I want Professor Hawkins to jump in. Professor Hawkins, why did I, as a political appointee under President Obama, have to show up at oversight hearings? I didn't realize there was an option of that I had the option of not showing up and not turning over my tax records also, by the way. Do you want to talk about norms?
I mean, I think that Professor Gonzalez said it, although I would say that it always brings to mind for me Chief Justice Marshall talking in McCullough versus Maryland about the nature of our Constitution. And he said that our Constitution is only designed to mark the broad outlines, right? That it can't do anything more. Otherwise, it not only approaches the prolixity of a legal code, but it imposes too much on us. And rather than allowing us to create government that is suitable for our needs, it defines it in too much detail. And so he understood that the Constitution, right, doesn't speak to a lot of things. And so even in that case, it didn't speak to whether or not Congress could create the Bank of the United States. But what he said is, let's look at custom and practice. What have they done? That should inform what is possible as a matter of constitutional authority. And so norms and custom and practice have always been critical to our interpretation and construction of a constitution that is by design, right, very broad and ambiguous, because it lends itself to allowing custom and practice to fill in those gaps and then dictate its meaning for subsequent application. So I think that, all the way back in 1816, we understood that custom was fundamentally a part of how we created constitutional meaning.
Professor Honig?
Yeah, so the idea, I'm a big believer in norms. I think norms are crucial to our format, but I do want to say norms are not inherently or automatically good. I mean, a lot of the problems that we've had in our country's history, a lot of the racism and sexism and other problems have been based in norms. I mean, there are millions of them. If you go back to 1950, I'm sure it was a norm. You wouldn't dream of appointing a female to be Secretary of State, right? There's no law against it, not illegal, but it was the norm of the time, was something you just didn't do. So there are bad and there are good norms. That said, I think there are far more good norms. I think we need to have some sort of informal process for when we change them. Yeah, I agree with something that Professor Gonzalez said. We have this structure put in place by the founders, but it doesn't answer all of our questions. And a lot of the questions I get from students, from viewers, from readers is, who can stop this? So how can this happen? The answer is, our system really builds in a supposition that people act with a certain amount of good faith. They always necessarily exercise the max amount of power they can get away with. This administration has challenged. I'll give you three ways that are really important to me that that administration has challenged in norms. One, exactly what Professor Gonzalez said with congressional oversight. I mean, they're not even playing games. Donald Trump said back in last April, after the Mueller report, Donald Trump walked the lawn of the White House and said, and I quote, "We're fighting all the subpoenas." And sure enough, they fought, and the courts have taken unjustifiably long time, forever. And as a result, they're losing these court decisions, but they keep getting, the Trump administration is getting crushed in the courts, but the courts take so long and there's appeals and rehearings. We're still spinning our wheels on the Don McGahn case. Remember Don McGahn? He was a key player in the Mueller investigation, which came out a year and a half ago. And part of that blame, by the way, falls on Congress. Jerry Nadler has been very slow and very timid to enforce his subpoenas. He's got a lot of rhetoric, but you know how long it took Jerry Nadler to go to court to enforce his subpoena on Don McGahn? 4 months he spun his wheels before he even went to court. That's number one. It's really number two in my order. Number one in my order, this is maybe from my background, is the wall of separation between the Justice Department, in particular the prosecutorial function of the Justice Department, where I used to work, and government and politics. I mean, the things that Donald Trump tweets out 10 times a day are more intrusive, more problematic than anything that any president has done. I think if you add up all of the public undermining of DOJ, attacking of prosecutors, of judges, of jurors, on Dr. Stone case, he attacked a civilian juror. This is degrees beyond anything we've ever seen. And I think it's very harmful. And we'll talk more about the way that the president, he's already used, and Bill Barr is his willing accomplice, has used the power of the Justice Department to protect political allies. And I think we may soon see the even worse extension of that, which is to go after political enemies. And the third one is the election and balloting. And that's happening every day. Yesterday, the day before, the president saying, well, not sure I'm going to concede. Every day it's the drumbeat of the last several months. Mail-in ballots are fraudulent. There's mass fraud. Bill Barr is straining like mad to give him examples, none of which pan out. It's a fiction, but he's trying to delegitimize this election. And there are many more, turning over your tax returns, emoluments, the way he deals with the press. We could go on and on. But look, this is a stress test unlike anything we've really seen before. And the election is going to be the ultimate stress test.
Yeah, I just want to use that as a jumping off point. There's something that caught my eye this morning in the Times, and also just sort of this notion that Professor Honig was raising about whatever the thing is today. If you think back 10 days, it seems like 10 months ago, because that was a totally different norm, blowing up norms. So I'm going to go back just a couple of weeks. This is something that just came through my, kind of electronic internet world. Somebody posted this on September 12th, not that long ago, right? Just a few days ago. This past week, Trump Woodward tapes confirmed Trump lied to public about COVID. DOJ takes over Trump defamation lawsuit. Department of Homeland Security whistleblower says Department of Homeland Security's doctoring election interference intel. CDC press aides are scrubbing COVID info, right, overruling the scientists at the CDC. And DOJ official quits the Durham team because Barr is pushing for an interim report before the election. That's not even a complete list for that week, okay? And it's like we think back, like, oh, I do remember those, but it's now like, way back in our mind, because even though it was just back in September 12th. That's enough. That list alone would be too much for a 4-year term. That's 1 week. Okay, so let's see if I have this available. Today's reporting in the New York Times, not even the top of the page, right? Down the page. Senior leaders at the Pentagon, speaking on condition of anonymity, acknowledged that they were talking among themselves about what to do if Mr. Trump, who will still be president from Election Day to Inauguration Day, invokes the Insurrection Act and tries to send troops into the streets, as he has repeatedly threatened to do during so on and so forth. What is going on right now? The problem is that we've seen this over and over. Under the text of the Insurrection Act, all the president has to do is issue a proclamation where he makes a pro forma declaration that there is insurrection, and under the delegated statutory authorities he has under the Insurrection Act, he can then deploy U.S. military forces into any part of the United States, or the designated part, to suppress the so-called insurrection. And really, there's nothing to stop that except the generals in the Pentagon saying, I won't do it. And they're talking. It's reported that they're saying this could, a month from now, this could be what we're asked to do. How should, or not a month, 6 weeks from now.
But it's already happened, right, in Seattle. I mean, it's
absolutely.
It's not hypothetical of what could happen. It has already happened. So
this is it. Is that we have, Congress has delegated by statute vast and very vaguely and loosely defined powers. The Supreme Court takes forever and is even when the day comes is reluctant to check these delegated powers. And Congress is also disabled in its ability because of partisanship, because they can't even enforce a subpoena, right? And they can't get the court's help to help them enforce an oversight subpoena. And so, in the past, what has prevented this from happening are these norms. It is the norm of federal government actors, the president, the courts, Congress, refraining from pushing to the absolute wall their potential hypothetical constitutionally or statutorily authorized powers. This president doesn't do that. And what we see is that this whole theory of separation of powers and checks and balances, it has failed. Congress is not a check. The courts are rarely a check. And if they are, it takes forever. And it is, so it is incredibly scary. And, sort of how do we deal, what are we going to do? Let's say Biden wins the White House and is sworn in 2021. Are we just going to muddle along with this creaky, highly imperfect constitutional structure that's buttressed by norms that can be just torn asunder with the wrong person in the White House? Or are we going to fundamentally, rethink how the separation of powers has failed and enact some formal norms to address it? And I'll end my rant there.
Professor Hawkins, what do we do?
Yeah, I was just going to say that part of how he's effectuated this, exercise of, strongman unilateral power across all of these areas is because I was, reading a Brookings study that was released today about how he really, and we've seen this, he's hollowed out federal government, right? There's just not a lot of checks and balances to stop him. And the places where he does have people serving, they are complete loyalists, right? So we know that he will not appoint anyone who is not an utter loyalist to his cause. That is the only criteria for service in this particular administration. And so they say that, 39 key positions across 15 departments of the federal government were never filled during Trump's first term. Currently, 131 key positions are vacant. Over half of Justice Department positions that are critical to the administration of the federal, Department of Justice are vacant. And so again, there's really no effective operation of the checks and balances that ordinarily would exist. And we've seen even career civil servants have been pushed out, whistleblowers who have been forced out, or people who have been forced to resign under duress because they have simply been unwilling to go along with this administration. And so the hollowing out, I think, of particularly the federal administrative branch of government has allowed this kind of behavior to go completely unchecked.
Yeah, and let me turn it to Professor Honig. Like you, I worked in the Department of Justice, and know that you're inculcated early there that you represent the United States, That is sort of part of the ethic, I think, of working at the Department of Justice. Talk about the Attorney General and the Department of Justice today, because I know that we've seen resignations in the Department of Justice from people who have had just extraordinary careers within the department, about really, I think, sort of the shift in orientation, starting with Attorney General Barr.
Yeah, so I served 8 years in the U.S. Department of Justice in the Southern District of New York. About it was almost exactly 4 under George W. Bush administration, 3 AGs, Ashcroft, Gonzalez, and Mukasey, and then 4 under the Barack Obama administration, all of those under AG Eric Holder. And I can tell you that what Bill Barr is doing is different, not just in degree, but in kind from anything we've seen before. And I'll tell you what I mean by that. Bill Barr, first of all, look, there's a tradition in both the law and media that you don't call someone a liar. You say, well, he missed it. Bill Barr's a liar. There's no way on that. He is a liar. He has lied about everything from the Mueller report to just the other day he got caught lying, tried to jam this whole narrative of ballot fraud. And he said, we did a case involving 1,700 fraudulent ballots in Texas. Well, guess what? That was state prosecutors. And guess what? Involved 1 ballot, not 1,700. So he's dishonest and he's overtly political, overtly. And by the way, we knew this. He told us who he was, because if you remember, before his nomination and before his confirmation, he wrote a memo. He said, oh, I just wrote it out of concern. I wasn't auditioning. But you know what he said in that memo about the Mueller investigation, which was the biggest thing at the time? He said it was fatally flawed, fatally misconceived. And look, I mean, the Democrats in the Senate did all they could. It was a straight party vote. All the Democrats voted no. Then Barr gets in, twists the recusal rules to allow himself to stay on the case, or already expressed a positive opinion. And as he do, he lies to us all about the Mueller report in a way that I don't have, completely ends up twisting, holds it back from the public, the Mueller report. It took him about a month to release it, puts out his spin, which really has become the dominant narrative, that Mueller report found nothing when the Mueller report found quite a bit. Since then, he has inserted him into the Roger Stone case, the Michael Flynn case, in unprecedented ways. He has undermined his own prosecutors. Look, don't get me wrong. The AG is the boss. The AG went on a very arrogant rant about this last week. And if you may remember, he said something like, who do these people think they are? Junior people don't get to run the show. That may work in a Montessori preschool. I'm paraphrasing here, but he did say a Montessori preschool, but that's not the way real life works. This is a classic argument technique. He takes a position that's uncontroversial. I'm the Attorney General. I have authority over the Justice Department. No doubt. The problem is he has only exercised that authority in very selective, obviously political ways. I mean, DOJ charges 60, 70,000 cases every year, give or take. Which two? What are the only two? Bill Barr has come down from his perch, undermined his prosecutors, not just undermined them behind closed doors, let them go on record in public, fully vetted and approved in the DOJ, and then undermine them at times, by the way, for a bunch of Trump tweets, giving him his playbook. So, I mean, does he think we're idiots? Does he think it will believe it's just a coincidence that out of 60,000 cases, he just happened to be involved in 2 of them, Michael, Roger Stone, and the stuff, and look, it gets worse by the day. I mean, just yesterday, the Middle District of Pennsylvania, we know Pennsylvania is going to be a key swing state here, issued a press release saying, we're doing an investigation and we found 9 ballots that had been discarded, whatever that means, and all 9 are for Trump. And then, okay, a lot of problems here. Problem number 1 is they got their facts wrong. It turned out not all 9 were for Trump. Problem number 2 is you never, this is a norm, but this is also in the written justice manual. You never comment on an investigation. That is nothing but trouble. That is against DOJ policy. That is against DOJ practice. And why would it turn out that they're just, and by the way, whoever those ballots were cast for has 0 relevance. Even if you are describing this investigation, even if for some reason you need to buck years worth of policy and practice and announce this pending investigation, the fact that those ballots were, well, however, we don't even know, unreliable, but they initially said all 9 for Trump is completely irrelevant to whether there's fraud, so just yesterday, Norm, it was a press release. Oh, and by the way, you know how quickly the president on that? This morning, his chief of staff, Mark, was on TV holding that, going, look, fraud in Pennsylvania. So DOJ has really been badly compromised by Bill Barr, and like Dean Lopez, they're going to have to, no pun intended, raise the bar back up one time.
Yeah, and I want the students, if you have questions, either use the chat feature or raise your hand. We'll run you live. I want to ask you, Professor Hawkins, I wanted you to join this panel because you've done a lot of work on judicial nominations and really the absence of diversity. And this has been a big issue in the political election about President Trump's success with judiciary, but it is not a diverse group of judges and not particularly qualified with respect to the assessment of the ABA. Do you want to talk about really the norms in that process as well, the judicial nomination process? Because there's been, from my perspective, it seems like there's also been a lot of kind of veering off the traditional path in that area as well.
Absolutely. So first of all, it's important to note that while we have this outsized fixation with the Supreme Court, a very, very, very small percentage of federal cases will ever be heard or decided by the Supreme Court. And so really our lower federal courts and the circuit courts in particular remain the last line of legal defense for many, many people. And so we focus a lot of attention on the Supreme Court, but our lower federal courts and the circuit courts in particular are extraordinarily important. That being said, while Trump might be allowed to nominate and confirm yet another Supreme Court justice, he has filled about 1/3 of circuit court seats. during his one term. I mean, it is far outpacing anything that any prior president has done in terms of confirmations. And one of the reasons why he was able to do that is that Mitch McConnell was very deliberate in the last 2 years of Barack Obama's presidency of blocking confirmations, right? So that Trump inherited one of the highest number of federal vacancies in the judiciary ever. And so Mitch McConnell really was very, very proactive in seeking to fill those vacancies. And one of the things that I wrote about in the paper that you mentioned, thank you, David, is the way in which those appointments have bucked longstanding trends, right? Norms around judicial appointments. And so one of the things that I note in particular, because my work talks about the intersection of law and diversity, is the way in which it has undermined the increasing diversity among federal judges on the bench. And so since the Carter administration, every president across political party has been involved in a project of increasing the diversity on the federal bench relative to their political predecessor, right? So for instance, while Bush 1 may not have made the bench more diverse than Carter did, he certainly made it more diverse than Reagan did. And again, successively, Bush 2 made it more diverse than Bush 1. And so what Trump has done is he has reversed this trend across decades and across both political parties of trying to build on your predecessor's legacy of improving the diversity of the federal judiciary. Why? Because we know that one of the things that gives legitimacy to our government is that it is reflective of and representative of the people. So in an increasingly diverse nation, we can't have an all-white male judiciary. Everyone has recognized this. Some people have expressly said this, like Carter, and made a concerted effort and an explicit commitment to diversifying the federal bench. Trump has reversed that trend. Again, he's appointed more white judges than all of his predecessors going back to Reagan. And again, not just lacking in diversity, but he is the first president that has not, I think since Nixon, who has appointed not a single African-American judge to a circuit court. Now, African-American judges represented the largest percentage of minority judges on the bench at the time that he assumed the presidency, and they still do. And yet, he has not seen fit to appoint a single African-American judge to a federal circuit court. He's only appointed a couple of Hispanic judges. They were the second largest minority group among federal judges. And so he has really reversed some longstanding trends. Not just that, but he's also bucked the norms in terms of the way in which he identifies judges, right? So there's no seeking input or advice from senators about who should be nominated. There is no looking to the ABA, Commission on Judicial Nominations, for vetting. In fact, Trump has nominated more judges that have been deemed not qualified by the ABA than any of his prior predecessors. And so he's bucking these long-standing norms around judicial nominations, both in terms of diversity and in terms of process and in terms of qualifications. He had the notable fact of nominating actually a circuit court judge for the first time who was designated as not qualified. And so, these are just consistent with what Professor Gonzalez and what Professor Honig have said about, there are all kinds of ways that Trump and his administration are simply abandoning long-standing norms. I mean, there's example after example after example, and that's true of his judicial appointments as well. And it's been made possible, the very pervasive effects of this have been made possible by the fact that he inherited such an enormous number of vacancies that he's had what will be a long-term impact, because not just the United States Supreme Court justices serve for a lifetime, all federal judges serve lifetime appointments. And so he's appointing young white males to the federal bench who will serve for their lifetimes.
So thank you. And we have some questions from the students. And I wanted to go back to you, Professor Gonzalez, because you seem to indicate maybe that you're about to call for a constitutional convention, but I want to get the students' questions out. How alive is the unitary executive theory under the current court? Do you expect the next president to also expand on this view of executive power? Interesting question. I'm going to just put them all out there. Why do the Democrats not use their power not to fund the government to force some reasonableness or norms? And then I think I have a couple of questions about expanding the court in November. So we have 15 minutes to solve the problems of democracy. Who wants to go first? With
so can I take that last question, and then I want to actually ask one of those questions to the constitutional professors.
Okay.
Can the Democrats, or what's the likelihood they will try to pack and expand the Supreme Court? Listen, it's fantasy world. I'm sorry. I know it's out there. It can be done. Okay. Our Constitution does not set a required number of Supreme Court justices. We've been at 9 by statute since 1869 for 150 years. Here's what has to happen. First, the Democrats have to win the Super Bowl. They have to win the House and the Senate and the White House. Then you're going to need enough of those Democrats who get elected to stay on board with this, when a lot of prominent Democrats have already said not going to do it, including not long ago, less than a year ago, Joe Biden himself said, no way, I'm not in for expanding the number of Supreme Court justices, because if we do it, then they'll do it, then they'll do it.
Uh-oh. Oh no, Professor.
It can be done, but I do not recommend investing a lot of hope in that. The question I have for the other professors is this. Somebody asked, can the, somebody sent out a news release that.
You're fading in and out.
Oh, is it?
So the news release was about 2 minutes for judges.
Well,
okay.
Why
don't you guys jump in?
Can I jump in?
Yes.
I'll very quickly give kind of the opposite idea on expanding the size of the federal judiciary. One idea that's out there is that the Democrats, assuming Biden wins, they get a bare majority in the Senate and retain the majority in the House, that they should actually expand the size of the federal judiciary in the first year of this hypothetical Biden administration. And then by the time the midterm elections roll around, and certainly the presidential election rolls around in 3.5 years after that, these sort of, process things don't really move votes. The Democrats won't really pay any negative electoral price for that. So that's one, you can assess whether that's right or wrong, but that's an idea that's out there that you might as well do it, because really there's a long history of these sort of process issues not really changing the way elections turn out, especially if their elections are 18 to 24 months away. On the normative side of it, I don't see any reason for the Democrats to not expand the size of the federal courts. The federal courts, wholly apart from partisanship, the federal courts are too small. They haven't been expanded since the Carter administration. It takes too long to adjudicate cases. The federal court should have the capacity to resolve, federal litigation and diversity jurisdiction cases that is commensurate with the size of the economy and the growing population. And so they could use that as a completely valid justification, even though certainly there would be political motivations behind it as well. And as far as expanding or responding to denial of the Obama seat in the last year of the Obama administration, or ramming through someone to replace Justice Ginsburg, I don't really think there's anything wrong with adding to the size of the Supreme Court. I like the ideas that are out there that seek to create some sort of rotation of federal judges who actually sit and hear cases. So you could rotate federal appellate court judges in and out on, you could do it every year or every 3 years or whatever. And also proposals that structure the Supreme Court so that every president would get, 1 or 2 appointments as justices rotate off. They would still have their life tenure as federal judges, but they would, your service as a federal judge on the Supreme Court would not be forever, and you'd be rotating off. And so it would kind of depressure or just kind of release some of the steam of the political pressure of the court by having an ever shifting composition of federal judges who actually sit as Supreme Court justices in hear cases. There's lots of ways to kind of de-escalate and just to get back, also this ties into what Professor Hawkins was saying about the eroding norms on appointments to sort of de-escalate that, at least at the Supreme Court level. So I'll stop there.
Professor Hawkins, do you want to also weigh in on the unitary executive, the power of the purse, if you want?
So yeah, I mean, I agree with Professor Carlos that Professor Gonzalez that I think
Professor
that just
C, we call him Professor C.
increasing the number of justices without also relieving the kind of ideological, raw, partisan kind of dynamics is not useful, right? Because you can increase the number to 11, but then now it's about 6 to 5 instead of 5 to 4. If so under some state Supreme Court systems, there's a required ideological balance, right? So as Professor Gonzalez said, allowing each president to appoint some, or making sure that you maintain some sort of ideological balance so the court is not so heavily politicized, right? And so everything is not about ideology and partisanship, especially insofar as nomination and confirmation. In terms of using the power of the purse, I mean, I think that what we've seen in the last couple of administrations is that government shutdowns are not popular, and the party responsible for them suffer grave political blowback. And so that's not something I think that the Democrats are willing to leverage in order to force the Trump administration to try to act consistent with political norms, because that really is something that not just hurts the federal government. The federal government administers programs on behalf of the American citizens, right? So at the end of the day, American citizens suffer, and there are career servants who are in the federal government who would suffer because of the politics of elected officials. And again, people don't like the consequence of the partisan bickering between elected officials falling down on average American people. So I think that that's it's theoretically possible, but politically it's untenable.
I'd like to also, Najib Raj had posted the question about the unitary executive. I want to briefly address that. He asked how alive is the unitary executive theory in the current court, and do you expect the next nominee to endure? I guess if it's Amy Coney Barrett, I don't know what she'll say on that. But given that she's kind of been swimming in these Federal Society waters since law school, it wouldn't surprise me if she's an adherent to unitary executive theory. Very briefly, unitary executive theory is an interpretation of the president's Article 2 constitutional powers that centers on the idea that the president alone possesses all of the power of the executive branch, and that any attempts by Congress through legislation to delegate power to the president's subordinates and then prevent the president from controlling those subordinates is constitutionally suspect. So is it alive under the current court? It absolutely is. All of the Republican appointees they've gone through the Federalist Society sausage maker. So this is part of the dogma. And also getting back to what Professor Honig was saying about Attorney General Barr and his comments last week, and he's made several other speeches and comments in his time as Attorney General during the Trump administration, and even well before. He is a very strong adherent of kind of a very extreme iteration of the unitary executive theory. And what does this really do? It operates to give an intellectual and scholarly veneer to a particular way of understanding the constitutional powers of the executive branch and of the president. But then returning to my original comments, my view is that this is all just sort of a fabulism. It's kind of made up. It has some sort of quasi-plausible hook in the text of the Constitution and perhaps even some evidence to support it from original understanding. But my view of the Constitution, especially as it relates to the powers of the president and Congress and the federal courts, is that it just doesn't really answer these questions for us. And so we have to answer them. Every succeeding generation has to answer them anew. And so I really view the adherence of the unitary executive and trying to claim that that was the original understanding of the Constitution. I view the evidence for that to be very weak. In fact, the counter evidence I think is stronger, but nonetheless, it has enough intellectual plausibility that they can use this to prop up of these ideas of expansive executive power. I have an old friend from law school. He's now a professor at the University of Virginia. His name is Sai Prakash. And it's interesting because he's an avowed originalist, a very conservative individual, and he's a constitutional law professor as well. And his scholarship is very conservative as well. And all the way back in law school, he and I would go through these debates. He recently published a book that builds on other law review articles that he's published in the past, where he generally argues for a return to a concept of the president's constitutional power as merely a caretaker and almost a kind of a bookish administrator of the programs that Congress has legislated. So he envisions the president, or he advocates the idea that the president should, we've kind of blown up the president to be something, at least in the domestic realm, leaving aside war powers and diplomacy or foreign affairs. In the domestic realm, we've really, over the decades, blown up the president to have all of this ill-defined, vague, delegated statutory power. We really need to return to a conception of the presidency and of the president as someone who's there to just dutifully enforce and apply the federal programs that Congress has legislated. So his view is much more of a government directed by Congress, and the president is a faithful executor of Congress's commands. And clearly that's not what this president is. And to be fair, neither have presidents been kind of this minimal sort of president for many, many, many decades, at least back to, we could say, Lincoln, or even further than that. Now, he comes to that conclusion because he is an originalist and he claims to have evidence of original understanding. I don't find that persuasive, but I come to the same conclusion from a different direction. I just think that normatively, this is a much better way to structure our separation of powers. I would hope that in the aftermath of the Trump presidency, whenever it ends, either in a few months or in 4 years in a few months, that we start to rethink the constant flowing of power that's ill-defined and not checked into the executive branch, and reconceive of the president as merely a bookish administrator and a faithful executor of the commands of Congress, which is a concept that we at least purport that the federal courts are supposed to adhere to when they interpret and apply federal statutes, right? The federal courts do not put themselves out there as we get to shape policy when we interpret federal statutes. They at least purport to be seeking the meaning of the text and applying the meaning of the text, or for an earlier generation, the understanding of Congress that passed the federal statute. But why don't we do that for the president as well? A lot of these problems of executive overreach would disappear if we fundamentally reconceive the concept of the president along these lines.
So you're saying the president can't cancel critical race theory in the public schools? I'm being a little
not under my view. The president would really, we would conceive of the president as really trying to figure out what Congress was trying to get done, and just not really have a lot less discretion to formulate policy, and basically just ignore Congress's commands, which is what you see this president do quite a bit.
Okay, I'm having fun. I have 15 minutes left that I can keep this open. I don't know about the guests. Can you go on for another 15 minutes, or do you guys have, because we haven't solved the problems of democracy yet. And I know that there's like a thread about a constitutional convention or something. Do you guys have 15 minutes to go? Can you give me 15 minutes? Yes? No? Okay, we'll go until 1:30. Then we gotta shut it down. The dean's gonna cancel.
Can I pick up on Professor Gonzalez's last point?
Yes.
And also Professor Hawkins's prior point. Here's how extreme the vision of the unitary executive is in this administration, at least Bill Barr. Bill Barr has said in writing that in his view, the president has unfettered authority to stop or start any prosecution, even if for political purposes and even if for his own personal purposes. I mean, talk about something with no bottom. And one of the challenges that the next administration will face, whether it's a Democratic administration in 2021 or the next Republican administration in 2025 is resisting the urge to keep the bar very low, right? So the bar, not the William bar, the hypothetical bar has been lowered so far by this administration. And believe me, when the next president gets in there, there's going to be every temptation to go, well, they did it that way. They cut this corner. They defied this norm. It would kind of be nice if we could as well. Like, here's an example, congressional subpoenas, right? No administration prior has just outright defied congressional subpoenas across the board. It's always been a back and forth, a push and pull, a negotiation. Okay, we'll comply with this one. Why don't we negotiate that one? Maybe we'll go to court every so often. When the next administration gets in there, let's say Joe Biden wins, when he starts getting hit with congressional subpoenas, if the Republicans control either house or even if Democrats control the house, it's going to be mighty tempting for his counsel to say, just do it. Let's just do what Trump did. Let's just say we're fighting them all. It kind of worked for him, right? And there's nothing really on the books to stop that. And the question is going to be, can later administrations resist that urge and maybe to their own temporary or short-term detriment, raise things back up again and restore some of the norms?
And let me just build on what Professor Honig was saying is that, you know, that's how norms erode, is that, you know, it's tit for tat. One side does it and the other says, well, they did it and they got away with it and we're going to do it too. And I think it's important to recognize that these informal norms have been eroding for a long time under presidencies of both, you know, Republican and Democratic presidencies in the domestic arena, in the war powers area as well. So it doesn't begin with Trump, although you know, I would, the analogy I always use is sort of like when you're making the hard-boiled eggs. You turn the water on and you put the eggs in and the temperature rises and rises and rises. And just before boiling, that water is, you know, it's not cool water. You don't want to put your hand in there, but then it really suddenly starts to boil. The Trump administration, the pace and the scope and the quantity of just totally ignoring these norms, it's not comparable to prior presidencies. Although, you know, other presidencies violated norms as well. They were just sort of very selective and kind of sort of saving their little trump cards, their wild cards for when they're not going to follow a norm for select situations. But now that, you know, so many of these norms have been broken, what is to stop the Biden administration, if there is one, from just saying, well, you know, there you go, absolute immunity. None of the heads of the executive branch departments need appear before Congress for oversight hearings, and we don't have to turn over any documents. And sorry, Congress, your ability to conduct oversight over the statutory delegations that Congress gave the executive branch is completely disabled. There's a sense in which the administration that scrupulously adheres to the norms self-limits its power, right? There's almost a perverse incentive structure to say, well, you know, we can't let the other side violate the norms and take advantage, but you know, we are going to play clean. You could, maybe it's sort of like doping in sports. If some of the athletes are doping, all of them have to dope. But this whole concept of it just, you know, again, this whole concept of simply not submitting to congressional subpoenas for legislative oversight, that is only possible in a world where we conceive of the executive branch and of the president to have these independent, immense, expansive powers. But in a world where we conceive of the president as a much more limited figure, that would be laughable, right? Because that model of separation of powers would be built on the notion that Congress is really in charge of government, and the president is just supposed to sort of in a bookish, almost like an accountant, administer as a faithful administrator the programs that Congress has legislated. And any notion that the president can say, no, Congress, you can't look over my shoulder, would seem absurd, right? It's only because we've kind of gotten into this overly expansive concept of the president of the executive branch that when the Trump administration says, well, we don't really have to show up for legislative oversight hearings. We don't have to respect or honor those subpoenas, that it can get some semi-plausible intellectual currency from unitary executive types and Bill Barr, who comes forward with a talking point to say, well, this is one of those things that's in dispute and this is how we view it. That can't be in dispute under the kind of model that I would like us to move towards. Yeah.
I have a question from Stephen, and then I know there's a question for Professor Honig in the chat. Stephen? You're on, sir.
Got his picture.
We see your picture, Stephen.
Great. I was actually just typing on my question. I wasn't sure if you were going to be able to get to me. But I mean, it sounds like, well, first of all, thank you everybody for taking the time to do this, but I'll be very quick. I mean, it sounds like the common theme here is that the Constitution itself is vague and perhaps that its writers presupposed a respect for traditions and values and norms and the rule of law in general. So my question is, I mean, are there any enforcement mechanisms that a unified majority and a Biden administration could enact to prevent this level of violation from ever happening again, going into the future, to prevent somebody from openly flouting checks and balances akin to Andrew Jackson saying Marshall has made his rule, now let him enforce it?
Yeah, it's one of the fundamental questions that the next administration will face no matter what. To what extent do we need legislation or to formalize these norms? And look, over our history, broken norms at times have resulted in legislation. I'll give you two quick examples. Term limits. The two presidential term limit was a long-standing norm going back to George Washington, but it was never part of our formal laws until it became a constitutional amendment in the 50s after FDR broke that norm by running for 4 terms. Another one is nepotism. It was always an unwritten rule. You don't hire, if you're the president, you do not appoint your immediate family members to cabinet positions until who? John F. Kennedy appointed his brother, Robert F. Kennedy, to be Attorney General. As a result, shortly after Kennedy was out of office, the nation passed legislation banning nepotism. The Trump administration then twisted it in all sorts of weird ways to get Ivanka and Jared, but I don't want to go down that. They're obviously not cabinet heads, but they needed an opinion from DOJ saying that it was okay to bring in Ivanka and Jared, which is why we have these people in the White House. So yeah, it's one of the questions. To what extent do we need to codify these norms and legislate these norms? And it's obviously much easier to do. At this point, I even wonder if it's possible to do unless the same party has control of the White House and both houses of Congress. I wanted to quickly just raise 2 other things. One, let's reserve some blame here for the courts, because the courts, we have this notion, and I mean the lower courts in particular, in dealing with the imbalance in the balance of powers that has arisen. The courts take forever and they're gun shy. And I know as law students, you all think of judges, and early in your career, you think of judges as these sort of mystical beings, and they must have their dockets set by some magical formula. When you get a little older, like I do, you know these people who are judges, they're people, like they're humans. And you know how hard it is for a judge to move a case to the top of his or her docket? Here, oh, this case looks really important. Oh, look, I'm a federal judge in DC. This case involves a postal truck that had an accident and it's a suit for damages. That goes to the bottom. Oh, this is a case involving separation of powers between Congress and the White House. I'm going to do that. That's going to go at the top, and I'm going to rule on that tomorrow. Or I'm going to take those arguments on Friday, and I'm going to issue a ruling next Friday. The courts have just not done that. They are too slow. They are too stodgy. They need more personnel, as both professors said, that especially the lower courts are vastly understaffed. That's not political. New Jersey needs 17 new federal judges, according to the estimates of the judiciary. The other issue, I'm jumping all over here, the proposal that just came out from House Democrats, purely for show, obviously it's going nowhere in this administration, to limit Supreme Court terms to 18 years. My question, I wonder what Professor Gonzalez, and if she was still here, Professor Hawkins say, I think she must have had a Wi-Fi problem, is doesn't that need to be a constitutional amendment? Because the Constitution says shall serve during good behavior, which equates to a life term. Or can it just be legislated, which is obviously, I mean, a constitutional amendment is impossible at this point. You need 2/3 of both houses and 3/4 of the states. I mean, we'll never amend the Constitution again. But is it enough to legislate, or do we need an amendment? I'm interested in what Professor Gonzalez.
So let me respond really quickly. I want to make sure, before I forget it, make me respond to that last thing. Yeah, go ahead, Dean Lopez.
Professor Hawkins got knocked off. So we definitely apologize for that. I think she's trying to sign back on. But anyway, go ahead and tell us how we're going to save the world. 4 minutes.
Okay, so
save our democracy in 4 minutes.
I think maybe 3 things I want to quickly, very quick, because time's running short, address, and make me come back to that third one if I forget it. The notion of getting the federal courts to more quickly hear these separation of powers disputes. And it ties in with the question about, what sort of legislative reforms. That's something where Congress clearly does have the power to legislate regarding the jurisdiction of federal courts, and could actually legislate to require federal courts to more promptly hear these interbranch disputes, such as, does the executive branch have to respond to congressional oversight subpoenas, or whatever the issue might be. And that would prevent the federal courts from being too timid and too reluctant to get involved. So it's statutorily require them to do so. Now, my general view is that while we should take these sort of kind of technocratic, small bore statutory reforms seriously, we need a whole bunch of them. At the same time, that won't be enough. We also have to reconceive the very concept of the presidency along the lines I've been suggesting. And now I forgot the
18-year, the term limits on Supreme Court.
Oh, the term limits. And that also just sort of ties into my original themes, is that's an open question. I mean, it's just another illustration of how our Constitution doesn't provide clear answers. And so you can come up with plausible arguments on either side of that. You laid out one of them, which is, there it is right in Article 3, that the federal judges have life tenure during good behavior. How can you remove them from the Supreme Court after 18 years? The counter argument would be, they're still formally federal judges, or you could even still designate them as Supreme Court justices past the 18-year term limit period. But they only, and there's lots of different proposals, but one proposal is they only hear cases when they're substituting for a judge who recuses, so they kind of rotate off of full-time hearing cases after the 18, or some people have said 15, or whatever the term limit would be, 12, right? They're still formally Supreme Court justices. They still will, from time to time, hear Supreme Court cases and join or write opinions in those cases. But after the 18-year period, they won't be on the first line of Supreme Court justices, right? So there are kind of like there are arguable ways to conform with the life tenure requirement in Article 3, but still create what is mostly a rotating body that kind of has this regular turnover every couple of years. A new justice rotates on, and one or more rotate off.
Interesting. Yeah, that would be the way to do it legislatively.
Yeah.
Okay, let me formally at least end my part of this, and thank you both for joining us, and Professor Hawkins as well. This has been an outstanding conversation. I must jump off. I know some of the students may have questions, so the ACS said they will keep the line open. This is a very important conversation, and I think what happens often in these conversations is we never quite get to do, how are we going to get from here to the Constitutional Convention? And I don't know if I'm putting words in your mouth, but that seems to be where you're going.
That scares me, the Constitutional Convention. But
can we just get rid of the Electoral College?
It's a dilemma. I argue we have a really problematic, imperfect Constitution. Now what, right? Do we really it would also be kind of risky to have a Constitutional Convention.
But how do we live up to the finest democratic values? I think everyone has this sort of sense that we are having a crisis in democracy at this point that could continue to spin out of control. And the question is, what do we do?
I have two responses to that. One is, the most direct answer to all of these is voting. I mean, that's the most direct form of accountability. It's the only thing that moves most, certainly members of Congress, I would say. The other thing is just maybe misplaced, but we have to rely on people to abide by norms and to act in good faith.
I don't think people are going to abide by norms. The norms have been slowly eroding, and then we have this bull in the china shop come in and just, throw everything asunder. It's possible maybe a Biden administration will sort of return to some of those norms, but even in the best case scenario, we're still on this sort of slow glide path to the norms eroding. If you can sort of turn back the clock to the day before the Trump administration, I mean, it has to be said, the Obama administration and the Bush 2 administration before that, they also engaged in certain things that, they kind of pushed the envelope on some of these things and didn't follow what had thought to have been all of the norms in all instances. And so the best case scenario is you kind of return back to this, it sort of works, but it's really not very good system where informal norms play a role, but they nonetheless are slowly eroding. So that I'm on the other side of that. I would prefer kind of you have to do a full makeover here, not a, just sort of return to this old rickety constitution that is a little bit buttressed by these unstable norms, right? What is the norm, right? You have Mitch McConnell saying the norm is we don't confirm a Supreme Court justice in the last year before an election, and then Ginsburg dies and he amends the norm, right? Now the norm is, oh, well, we do that when the president and the Senate are a majority of the same party. And so I've long been skeptical, and I am even more skeptical that norms are going to save us. And I'm also skeptical that Madison's system of checks and balances really works very well. You can have a system that is problematic and it doesn't implode for quite a long time. And I think that's what we've had for 60, 80 years. But then eventually some event happens, or in this case, maybe it's an event or a person comes along and really kind of exposes all the flaws that were always there. It's really kind of hard to unring that bell, in my view.
Thank you both. Any other final thoughts, Professor Honig?
No, thank you. Thanks to all the students. I know this is a strange semester for you. Thanks for queuing in. Let me just say this to the law students out there. I know the psychology of law students. I know you're all freaking out because you're at home and you feel like you're missing out, FOMO. You're not missing out. Everyone's in the same boat. There's not secret job fairs happening without your knowledge. Hang in there. You got plenty of time. We'll all come back together. Don't stress. Do your work. Get your grades, and you'll all be back here soon enough.
Thank you both.
Okay, signing off. Thanks. It was fun. Bye.
Thanks.